Hey guys, welcome to this week's episode of the Advisory Board Podcast. We've got an expert with us today. I'll do a brief intro of him. So Christian Thompson is an attorney. Now, he's not that kind of attorney, so don't be too disappointed. But he's an expert in franchise and multi-unit and business law. He's also an exceptional football player, great dad, an architect of fine playhouses, and a lot of other cool things. Now, Christian, before I spoil it, why don't you take a minute? Tell us a little bit more about yourself and about your firm and some of the specialties you guys have.
Yeah, you left out groomer of fine mustaches.
That's true. I did leave that out.
Recently. So our firm is called the Franchise and Business Law Group. We're located in downtown Salt Lake City. We've got 4 franchise attorneys and mostly represent franchisors. Do have a number of multi-unit developers, other franchisees. And the founder of the firm, the godfather of franchise law in Utah, has been doing it for 40 years, and we do trademark law and employment law and things like that. So we try to be able to cover all the bases for our franchise and business clients.
That's great.
Yeah, been practicing 10 years, I guess over 10 years now, and really enjoy it.
Great. No, I've heard good things. I was introduced to you by a mutual friend who highly recommended you. So that alone gives it good credence. Now, I have to ask a serious question about the Godfather. When you joined the firm, did you have to kiss a ring? Was that part of the ceremony?
I can't tell you.
Nice. Hey, Christian, well, I'm glad you're here. Thanks for making time to join us and share some of your knowledge and experience and the experience of the firm. And I thought, because so much is in turmoil right now, and it might be again, so I think this is relevant, very relevant now, but also will be in the future. A lot of the franchise systems that we work with, they're having to innovate, change the way they operate. The restaurants are all doing delivery, dine out, kind of curbside stuff. But the service industries, they're delivering services totally differently than they were before as well, if they can. Which means a lot of them are deviating from maybe operation agreements and processes that they've agreed to as part of a franchising agreement. Do you mind maybe sharing some insights about, as a franchisor, how can you make sure that even though there's innovation and deviation happening in the system, you maintain some legal flexibility, but also some controls, so you don't open yourself up to liability or deviations that are too significant?
Yeah, so those are good questions. As you mentioned, I mean, now is the time for clients to be a little flexible. Franchisees are trying to survive the best they can, and those that are able to survive are doing it well. I had a client who said, this is the time for big winners and big losers. Those that can adapt are going to be on top. I heard a statistic today that 1 out of 5 restaurants is anticipated to close in the next year. And so those that will survive, they've got less competition. So franchisees, along with the franchisors, everybody wants to survive. And one of the things we tell our clients is like, okay, look, if suggestions are coming from the bottom up, which you should encourage, like franchisees are trying to innovate and do things too, so they may have great ideas. Back in the day, the drive-through concept was from a franchisee of McDonald's. Initially, they were put in default for the introducing a drive-through, but that cooler heads prevailed, and now every restaurant that's a standalone has a drive-through. So there's going to be great ideas that come out of this. So if it comes from the bottom up, if franchisees are suggesting and the franchisor wants to implement it, they can do a couple things. One, they can say, all right, we're going to test it at your facility for a time. And anytime you do some sort of deviation or allow some sort of lenience or a new innovation, you should get it in writing that saying, okay, let's test this for a time, but after X number of months we can pull it. And so the control and the final decision stays with the franchisor. And the franchise agreement, if it doesn't already have it, we try to write into our franchise agreement saying if there's innovation from the franchisees any innovation that becomes adopted by the system becomes part of the system, becomes the franchisor's trade secret, and we don't owe you anything for it.
Yeah.
And so if it's not in there and you start to allow these things, then that should be, that kind of language should be included in an addendum to say, all right, you come up with this, but it's ours. We can let you use it. I mean, kind of sounds heavy-handed, but that's how most franchise systems are.
Yeah.
So that's things from the bottom up. If they're adopted by the franchisee or introduced by the franchisee, the franchisor can can say this is allowed for a time and then roll it out everywhere. And if the franchisor wants to introduce changes, so from the top down, now the first question is, can you do that? Is it allowed under the franchise agreement? So does your agreement allow for system modifications? Usually that is yes. And usually the franchise agreement says, hey, we can introduce new concepts or new ideas or new systems that will require you to spend more money. It's going to increase your initial investment, at least initially. Obviously, franchisors would be wise to introduce something that doesn't cost too much money at this time because everybody's cash strapped. But if it's going to save the system, then obviously you want to do it. So supposing you can do it, then it's just a matter of, okay, do you want to introduce it kind of like we talked about before at a certain location first and then roll it out. And if franchisees don't have the money to do it at that time, you slowly implement it, or you come down with you could come down with a hammer, say, listen, everyone's got to do this or you're out. But the first thing you want to see is if it's allowed under the franchise agreement and before you introduce something like that. So
yeah, well, you bring up, if you don't mind me diving a little deeper into one concept there, and one, thanks. I think that's fantastic advice. Also, a good thing to make sure, if it's not in there right now, if you're redoing your FDD, make sure you add in something that allows for that. But what if somebody didn't work with your group to get their FDD written, and it's maybe not as robust as it should be in that area and doesn't have the built-in flexibility? What does the process look like to get an addendum executed so that they can actually now start to do this with some legal parameters to support it?
Yeah, I mean, if it's not in the franchise agreement, they can't force the franchisee to adopt it. I mean, if that were to happen. So if the franchisee did agree to that kind of change, again, put it in writing, and there needs to be consideration for it. So if I'm requiring something of a franchisee, there has to be some quid pro quo, or later it could be said, well, it's not enforceable because it's not a real agreement. And so maybe it's, hey, you implement this and we'll give you a reduction of your royalties for a month or something like that, so that they have some incentive to do it. And then there's something that can be shown as consideration on your side for implementing it.
That's great. Yeah, thanks for that, for diving a little bit deeper. I think that this leads to a couple of other key topics that come to my mind that are hot topics now, and things also that come to my mind because they were in the memo you sent me. So I appreciate the notes that you guys put together for your firm. With all the changes in turmoil, there's also a lot of anybody who's got a physical location right now has got leases due. But when you're talking a franchise system, oftentimes they'll have national agreements, or they'll have some leverage because some folks are leasing them multiple locations because they have multiple units. Can you maybe talk through a little bit some of the best practices you've seen right now as people are looking for some relief from a landlord? And also, second part of the question, sorry to stack them, is now that we're starting to reopen, what are some of the additional legal things that people should be looking out for? Some gotchas they might not have thought of.
Yeah, no, good topic. So with negotiating with the landlord, as businesses are reopening and things like that, most landlords want to keep their tenants. But landlords also have their own, they're in business too. They're trying to stay afloat. If they're paying a mortgage and things like that, they need cash. I'll just start with kind of the first way to kind of go about negotiating with the franchise or the landlord. Um, we have some clients that, got into a lease because it was in a mall or it was close to some sort of attraction like a theme park.
Mhm.
And now that those things are closed, or a convention center, it kind of takes away the purpose of why the client chose that spot and why it was valued at what it was. And
Yeah.
so, you're able to negotiate with the landlord to say, listen, this is, it was a material, basically, term of the agreement that this would be available, or at least both parties assume that the foot traffic and things like that would be part of the lease. And so we've had clients that, at least as of this last week, have been at least successful in getting um, discussions with the landlord. We don't know exactly what the uh, what result of that will be as of yet, but at least the landlord's willing to work with them and take that into consideration. Um, I've also heard landlords are willing to defer. That's probably happened as of March and April, maybe even May. The deferral is obviously nice, but it can get tacked on later, so makes the rent more expensive, and so that can be a gotcha. People don't understand that deferral means I'll pay you it later, and it is due. It's not a waiver.
Mhm.
Um, so that could be kind of a gotcha. And also, landlords are willing to maybe give more concessions and actual waivers of fees, lease payments, if there's some sort of renegotiation of the term. So let's say you've got a year left on your lease, or maybe 6 months. Now
Mhm.
is a good time to say, well, if you give us, rent abatement for 6 months, we'll sign this long-term lease. And landlords may jump at the chance of having someone there longer, because so many businesses are going under, or um, some commercial space is, people are moving to home.
Yeah.
Obviously, we're both working from home, and that's working out fine. But
Yeah.
so that's another thing to consider.
That's great. And so, out of curiosity, so if I've got a business, a lot of these are a lot of the franchise systems have real estate in the malls. If the mall itself isn't open, I'm assuming that that's a fairly easy discussion, maybe even a proactive one that those landlords are having with their leasees.
Yes.
If they don't, if the building itself that gives customers access to the service isn't available, then I'm sure that's probably a more likely discussion.
Yeah, I mean, there's what's called a force majeure clause in most
Mhm.
leases, but they always say, "Oh, you're excused from performance except for paying us," and it's, that's kind of silly. It's like, what else am I supposed to do other than pay you?
Yeah.
Um, but yeah, a mall, absolutely. If it's closed down, that I would lean heavy on that force majeure, because it's like, well, you're not able to provide access, like you're not able to provide customers. So,
Mhm.
yeah, those kind of situations, the tenant has a better argument for some sort of waiver.
Yeah, and if you don't mind branching from there, like force majeure, uh, I'm fortunate. I've never been in a situation where I've had to try to execute that portion of an agreement before, but I think it's a reasonable time in history to try to use that. What are some other examples of places you've seen your clients need to use that clause to get some sort of relief from what's going on right now? And any ideas you could share on that?
Yeah, so, one of the things in franchise agreements will say, um, you have to follow the system entirely. You have to use our suppliers, and you have to use, X, Y, and Z. Well, there may be certain suppliers that are no longer able to provide the certain things, and so the franchisee in that instance could say, we got this. I'm unable to follow that right now. I can't. And so they can invoke the force majeure clause and say, well, it doesn't get you out of the contract, but it gets you out of at least following that. And again, like we talked about before, if there's some sort of deviation from the standards, the franchisor should put it in writing and say, okay, listen, I'm going to give you concession to source products from this place for a time, but as soon as that, you know approved vendor is back online, then you have to start using it, maybe with some runway to get back on track.
Yeah.
um,
Yeah, that's a great example. When you said that, it just reminded me, we've got some clients and partners, people that we know, that part of their franchise model is they have lower royalties, but they actually end up making enough money to keep the franchise, the franchisor going because of the product sales. And so I could see if there's an interruption to supply chain there, you definitely need to make sure that you're not letting that force majeure or loophole remain open indefinitely by putting a
Right.
consent in place. That makes sense.
Yeah, closing and having that, like I said, everything goes back to having it in writing,
Mhm.
where both sides understand what the expectation is, how long the waiver lasts for, and so the franchisor maintains control of that.
Mhm. Yeah, that makes sense. Well, this is kind of down the same thought process, but how about when Z's, as the franchisor, franchisees say, hey, we need to close, and that's not part of the agreement, is that we just get to close our door for weeks on end. How are you seeing, or how are you recommending that franchisors engage in that dialogue, because it's a viable need? And again, they might evoke force majeure. That would make sense. But how are you, or what are you advising people to do around Z's trying to close locations temporarily?
Yeah, so the first thing would be if the franchisee is in like a hot zone, like a New York City or LA County or New Jersey or something like that, where there are a lot of government restrictions in place that make it so you can't be in business for a time. If that's the case, then that's kind of like, all right, you have to comply with the federal restrictions and or the state restrictions, and that one's a little bit easier to say, okay, you can close for a time, and again, let's have this in writing so that once the restrictions are lifted, you have to open back up. The harder ones are in like an area that may not be as affected by the coronavirus, and it's more optional to close or stay open. If a franchisee wants to voluntarily close, the franchisor can allow it, but they can also say no. You have to keep your doors open. If it's something where it's unpopular in that area, where you look like you're kind of giving the middle finger to the government, and say, I'm not wearing this mask and whatnot, and now because so much of it's politicized now, and you don't want to look like your franchise system is taking a stand one way or the other.
Yeah.
And so franchisors have to be sensitive to that. They don't want to be saying you have to stay open in an area where it looks bad on the business to
On the
stay open.
brand.
In
Yeah.
that case, you're saying, okay, you want to maintain the goodwill of the system. You don't want to be on the news, and so that would be a consideration for allowing a closure. And on the same argument, if a franchisee wants to stay open and it's unpopular, unpopular is probably not something where a franchisor could mandate a closure, but a lot of franchise agreements say you can't do anything that would materially harm the goodwill of the system, and the franchisor may be able to use that to say, listen, you got to close your doors for the time being.
Mhm.
And so all that gets taken into consideration. Obviously, the franchisor wants to make sure that it has the right to require a closure or require them to stay open in the franchise agreement. The franchise agreement, if it doesn't say that, then it becomes a lot more difficult. But most franchise agreements will say something like, we can control your hours, we can control the days of how many days you're open and things like that.
Yeah.
And they'll always say something like, you have to abide by the local laws.
Mhm.
And so if a franchisee doesn't want to close, but local laws say they have to, then certainly you could say, you gotta abide by the local laws, shut your doors for the time being.
Mhm. Great. Well, that's great advice. Yeah, it's funny. I was thinking about the perspective of a franchisee saying, "Well, I want to close," but I wasn't thinking about the fact that the brand might need to close. That's really good advice, and certainly applicable, because we're seeing certain parts of the country. Let's not have a political discussion now, but certain parts of the country are making it a real political deal, and so news stations are loving to torment poor people that are trying to keep their doors open. Sometimes
Right.
it's not in the best interest of the brand's image nationally. So
Sure.
that's good advice. Hey, so another thing, so in every franchise system, and there's just no way around this, especially the larger they get, there are always those franchise owners that try to buck the system, are difficult to work with, are underperforming, and are locking up a key metro area that somebody else who put in the time and effort could triple, quadruple, the performance. And so a lot of franchisors, they look at that and say, well, maybe this is a good time to terminate Bob's agreement because he's underperforming. I know there's certainly some risk and some, it's not something you can just flippantly do, although it might seem like an opportune time to do it. Can you give some advice about that? Like how would you recommend people approach that? And also maybe why shouldn't they take that type of an approach?
Yeah. I mean, franchisors, I mean, everyone's always looking for to be opportunistic, either for the benefit, I mean, to, open more locations or close them for the betterment of the system. But with regards to a franchisee that may have just been like the problem child for a time being, and you're saying, well, now let's close them out. We represent mostly franchisors, but we represent quite a few franchisees as well. And a lot of times if you can paint the picture that it looks like the franchisor is singling this franchisee out and treating them unfairly or looking for excuses to get rid of them, it's sometimes easy to look through the franchisor's actions and get to the real intent. And that's a real argument. Like, you have to treat franchisees equally. And so I would say this, you can continue to enforce the franchise agreement. You can continue to enforce the brand standards. So if you've got someone that was a problem child before the pandemic and now they're a real problem child, if you're saying, well, okay, you're deviating from the standards, I'm going to give you a notice of default. That works, and you can do that so long as you're also sending that notice to all the other franchisees that may be deviating from the system. So you certainly don't want to terminate or send a default notice and terminate a franchisee for non-compliance if you're allowing 15 other franchisees to do the exact same thing and not giving them a notice of default. Yeah. So, I mean, our recommendation would be to be a little bit lenient during this time, but not so lenient that it harms the system. So you certainly can, enforce those rights. And there are franchisees right now. The successful ones seem to be. I've seen it with some of our clients, and I've also heard from other attorneys where the successful franchisees are buying out those that can't survive. So you're getting franchisees with, instead of 1 or 2 units, they've got 5 or 6. They're just buying up everyone around them. Yep. And so you will see some consolidation. And so if you do have a problem child right now, I think exploring options of saying, hey, you know what? Why don't we look for you to try to sell this? And you don't want to necessarily be orchestrating that, but you can facilitate it. But at the end of the day, if they're not in default, you can't force them out, and you don't want to be looking like you're looking for an excuse to get them out. So it is something that you have to be a little bit delicate with.
Yeah, no, but I really like that what you just said a minute ago, that and that's a win-win-win. Truthfully, if you've got an underperforming unit in your system, but his neighbor's killing it. I mean, I'm sure there's a fine line there, and sometimes it's just like, you don't want to break social mores, but are there legal implications if you were to approach the issue with that underperforming unit and try to encourage them to work with, the neighbor to maybe do a buyout because they're not passionate about the business, they're struggling, they're not getting what they thought they were going to get out of it, but now they could maybe cash out and get their initial investment and a bit back. Is there any legal restriction or any cautionary advice we ought to share about that?
So if you've got an existing franchisee that wants to purchase another franchisee's location, and you're kind of assisting with that, you probably don't, well, there's a disclosure issue usually. So what you want to make sure is that if you are doing that whoever signs the new agreement, so a lot of times what happens if if I'm a franchisee and I transfer my franchise to a third party, the franchisor generally says, okay, new franchisee, you have to sign the new franchise agreement. So the most recent one. If you do that, that requires an FDD disclosure. So you have to provide the FDD, at least 14 full days ahead of time. And so if you're not registered, let's say it's in California and you haven't finished your registration, you can't do that until you're registered. The other option would be to have the franchise, whoever buys, just assume the same franchise agreement, you could extend the term, but the provisions are basically the same. In most states, that will not require a disclosure. And so if you're not registered, you could do that. Same with the existing franchisee. They could just assume the new the existing franchise agreement rather than be redisclosed with the new one. But as far as facilitating it, I mean, for the buyer, you don't want to make any sort of representations to say this location you're going to kill it if you come over here, because now you got some potential claims from the buyer of misrepresentations. From the seller, as long as you're not squeezing them out, saying, putting them in default on kind of a bogus default notice to put pressure on them to sell, you certainly don't want to do that. So yeah,
that makes sense. That's great. No, I hadn't really thought about that before until you brought it up, but I think it's a very relevant topic right now. A lot of the franchise systems we work with are there. You will see consolidation every time there's a little bit of a downturn. The people that are just making it through often get a little nervous or can see the writing on the wall and want a way out, and that's an easy way out. So good advice, man. Hey, there's one last area that I thought I should pick your brain on, and I don't want to tie you up too much. So thanks again for making time to meet today. I know you're busy. What are some general, just taking a step back, you're in a unique position in what you do with business law practice and franchise business law. What are some of the key issues that we haven't talked about today that people should be paying attention to? Like, what are the most compelling things or things that you're seeing kind of bubble up right now in the legal world that business owners should be paying attention to, franchise or no?
Yeah. One thing, and do you want to talk about? I just want to make sure we hit on it before the FDD disclosure stuff.
Oh yeah, you know what? Yeah, why don't you share this advice and we'll jump to FDD. I totally spaced that. Yeah, we should definitely.
That's fine, because my mind was going, well, let's make sure we talk about that. So
yeah,
you want to talk about the FDD first, or
we'll wrap up with kind of some of your general wisdom.
Okay.
Yeah.
Well, that will just take a long time. I've got so much general wisdom. Okay, so with the FDD, this year, what we're seeing from state examiners is item 19 has been discussed quite a bit to say, item 19, it's your financial performance representation. That is an optional disclosure. Yeah. And so if you do give a disclosure, it has to have a reasonable basis, and you have to have, things to back it up. The one thing that is going around right now is saying, if you provide numbers, let's say a historical financial performance representation from like 2016 to 2019, showing your company-owned units, what they do, and your franchise units, what they're doing over those last 3 years, there's an argument that is, you do not have a reasonable basis for giving that anymore because the landscape's changed so much. Washington, the state of Washington particularly, is pushing back on that quite a bit and saying, well, why is it reasonable to give 2019 numbers when we're basically in a whole new universe?
Makes sense.
And that has not been fully resolved. And one of the things that the franchise, what examiners have said is like, hey, provide us an updated item 19 for what's happened so far in 2020. For some systems, that may not be a big deal. They do it, and it just shows how the locations are doing so far, and then they get it past the examiner. In other systems that are really big, that may be more difficult. to do, and just because it's more work and more cumbersome, and it puts more of an obligation on the franchisor. And so so that item 19, and if you do update it, let's say you comply with Washington, you're like, okay, well, I'm just going to do it for Washington, but I'm not going to update it in my other states. The problem is item 19, there's a presumption that if you make an item 19 change in one state, you have to make it everywhere across the board. That's not so true with other items, but item 19, certainly they're saying, hey, that's so important that if you make it in one state, you have to make it in all states.
Yeah.
So you have to keep that in mind. You certainly want to update your FDD, like if you've got a bunch of units that closed in 2020, because usually you just have to update that at the end of the the fiscal year. But if there's been half of your franchises are gone, that's a material change, and you want to update that.
Yeah.
And you want to be on top of your interim financials. So every quarter, franchisors should be providing interim, unaudited financials in their FTD. So it's item 20, item 19. Those are the big ones. Certainly, if you made if you're introducing a new way of doing things, that you want to update your FTD for that.
Yeah. If some of those concessions turn into practices, right?
Right. So you do have to be on top of updating your documents more this year than in normal. So that's the one advice with the FDD.
Yeah, good advice.
So going back to your general, I don't know if you want to cue that one again.
No. Yeah, just that you have a unique perception of what's going on in the marketplace right now. I mean, from my perspective, I see a lot of the sales and marketing strategy shifts and have some advice around that. That's not what we're talking about today, but in your world, you probably see a lot of different things that I think you could probably take a step back and say, here are 2 or 3 nuggets of where I'm seeing the market shift and where new liabilities are forming, or how to avoid certain issues that are starting to affect your clients.
Yeah, so I'll just give you kind of, it probably sounds more like business advice, but I'll just pass on to what I've seen some of our clients do. Because we've talked a lot about the legal, like if you do any changes, you want to make sure you have the right to, and you get it in writing. That's like, probably the biggest takeaway from this little session is get everything in writing, make sure you can do it. But as far as like adapting, what we've seen, some success stories. We actually have a restaurant client out of Florida, and they had their operation was pretty big, and they were always worried about franchising because it was too complex of a system, at least the way that they felt, and it was an expensive operation to operate. I mean, the revenues were high, but so were all the expenses and operating costs. So they ended up cutting their menu in half, and they realized they didn't need as many employees, and they simplified operations. And they called a couple weeks ago in the middle of all the mess and saying, hey, I think we're gonna push this for a launch. And I cautioned them saying, okay, anything new, like, so this would be a good piece of advice. So with them, I said, this may be taking off right now. Your profits are way better than before. Everything's simplified, but you need to test it a little longer before you start selling franchises with this new concept. So that's what I would say, with franchises in general. If you're going to make sweeping changes, it may be a good idea to pump the brakes just a little bit on sales to make sure that you've got everything in order. And right now it's, selling franchises, you certainly can do it, but there may be a lot of people that come in on relying on, the success in the past rather than what's going on right now. And it's easy to sugarcoat things and not be really open when you're selling franchises. From an attorney's point of view, you want the client to be as open as possible because it limits all these claims, but it makes it tough for the salesperson. So you kind of have to be real. And like I said before, there's going to be big winners and big losers. I think the customer experience needs to be kind of paramount because it's different now. I don't go to a dine-in restaurant and experience the ambiance and all that. The customer experience should be, it's likely how fast was it to get the order, and how good was the food, how nice was the, I mean, how easy was it? My wife went to, is it okay to plug a client and something like that?
Yeah, go for it. Yeah, please do.
So they went to, she went to Crumble Cookie. She had ordered something like she went to pick up dinner, and then she's like, I'm gonna get some cookies for the kids. And while she was in the drive-through for the other restaurant, she ordered the cookies, and it allowed her to pick any extras, customize her box. As soon as she pulled up to Crumble, she said, I'm here. They brought her right out, and she said that was an awesome experience. She didn't even have really any interaction other than with someone bringing her cookies, and she can't wait to go back. So that, and with like working at, I know a lot of workout places, like obviously Peloton's been doing it for a long time, but this shifting to working out from home, like making that experience still a fun experience, even though it's watered down a bit. I think that that's a big part of what people need to do going forward.
Yeah, it's great advice. Yeah, and there's nothing wrong with plugging Crumble Cookies, because they've got fantastic food, cookies as well as service. I've been impressed as well. Well, I appreciate it, Christian. You've given us a lot to think about. I'm just thinking about the deviation in writing. That's one of the things I wrote down. Making things time bound, the top down, bottom up innovation process. I appreciate your insights on that. FDD, item 19, item 20 considerations. It's tricky now, especially. It's too bad it's an election year with this all hitting, because it makes it a little bit more impactful, I think. But where some states are leading the way and deviating from what, or at least creating a deviation of what the people probably need to write into their FDD, it's wise to make sure they're making it universal, just like everything else in what they should be doing with the franchise system. So I think you've given us a lot to think about, and I really appreciate you making time to join us. Thanks a lot.
Absolutely. Thanks for having me.
Yeah, we'll do it again for sure. Thanks, Christian.
Okay. Sounds good. Thanks.